All right, in this explainer, we're going to unravel a pretty fascinating legal puzzle. What exactly does it take to make a valid will? You might be surprised to find out that a law from way back in the 1870s is, well, still kind of haunting our modern courtrooms.
So let's dive right in. Just picture this. A huge family inheritance is on the line, and the will gets challenged. The claim? That the person who wrote it wasn't mentally all there. I mean, this is a super high-stakes question, and it brings us right to a really crucial legal concept.
So, how do we legally pin down the mental state someone needs to be in to make a will? Well, it all comes down to a specific legal term, testamentary capacity.
So, testamentary capacity. That's the legal jargon for the bare minimum mental ability you need for a will to be valid. And if you don't have it, well, the will is totally void. But what does that actually mean in the real world?
Okay, and this is what's so wild. For like over 150 years now, the main answer to that question comes from a case that's, well, it's surprisingly old. It really is like a Victorian ghost is still calling the shots in our courtrooms.
Yep, the case is called Banks vs. Goodfellow, and it dates all the way back to 1870. We're talking about the will of a man named John Banks, and the court's decision back then, it literally established the foundational rules that we are still using today.
So the court came up with this three-part test. First off, you got to understand you're even making a will and what that means. Simple enough, right? Second, you need to have a pretty good idea of the stuff you own. And third, and this is a big one, you need to be able to think about who might have a reasonable claim to your stuff. You know, the people you might be expected to leave something to. And believe it or not, that's been the gold standard for more than a century.
All right, so let's fast forward to the 21st century. You'd think, finally, this old law was about to get a much-needed update, right?
So, in 2005, a big new law comes along, the Mental Capacity Act. This thing was huge, a really comprehensive piece of legislation designed to handle all sorts of issues around mental capacity for the modern age.
And it seemed like a no-brainer. I mean, pretty much everyone, legal scholars, judges, you name it, just assumed this new modern law would finally put the old one to rest. It just made sense, you know? A new statute for a new century.
So, that's it then? The modern 2005 law kicked the 1870s rule to the curb? Case closed? Well, in the legal world, things are rarely that simple.
And this, right here, is where our legal puzzle really kicks into gear. Because in a twist that surprised a lot of people, that 150-year-old ghost just refused to leave the building.
Yep, not exactly. In later cases, and a key one is Scammell versus Farmer from 2008, the courts basically said, nope. They confirmed that the old Victorian test, it wasn't replaced by the new act at all. It survived, and it is still considered good law today.
So what we have now are two totally different tests that exist side by side. You've got the old Banks v. Goodfellow test, which is kind of the default for most wills that people write themselves. But then you have the new 2005 Act, and that one applies in very specific situations, like when a special court has to step in and create a will for someone who can't.
And here's where it gets really sticky. The problem is, these two tests, they're not the same. And having two different sets of rules can lead to some really bizarre and confusing outcomes. Because what it means is that the very definition of capacity can actually change depending on how a will is made.
And this quote just nails it. A leading legal textbook, Theobald on Wills, points out the unappealing possibility of this whole situation. Think about this for a second. It means someone could be judged to lack capacity under one test, but have it under the other. A court could literally say a person had capacity when they wrote their own will, but then find they lack capacity under the modern test if the court needs to authorize one for them. It's a total legal paradox.
So, okay, why does any of this matter? I mean, it's a fascinating legal quirk for sure, but it's way more than just trivia for lawyers. This has some very real-world consequences.
So, what's the big takeaway here? Well, it's that the law doesn't always move forward by just replacing the old with the new. Sometimes it just adds another layer of complexity. That old ghost from Banks versus Goodfellow is still hanging around, making for a pretty complicated and unique legal landscape.
And all this leaves us with a final, really thought-provoking question, doesn't it? In an area that is so deeply personal, we're talking about a person's final wishes here, how should our legal system try to balance principles from a completely different era with what we understand about mental capacity today? Honestly, it's a puzzle the courts are still trying to figure out.